Next, I understand that the item agenda for 215, which is the proposed regulatory rule amendments, that we have folks ready to present on that. And so I would turn it over to Chief Regulatory Counsel Hanada Garcia and Associate Director for Regulatory Services Bobby Henry. Welcome.
Hi, everyone. Thank you for having me. Can you all hear me okay? All right, perfect. Bobby's going to be sharing a PowerPoint, so if we can give him access to do that would be great. So we have a few regulatory items on the agenda today, starting with the resident agent requirement. We are here to propose changes to the APR, the ELC, and the WSBA bylaws as it relates to eliminating the requirement for resident agent in the state. This is a two-part request. First, we are asking that the Board of Governors approve suggested amendments to the APR, to the court rules, right? And the second part relates to corresponding bylaw amendments that will need to be made. And that would be for first read today, and we would come back at a later time for second read. So the action item today is to approve the actual court rule recommendations. So the second slide. So just to provide some, general information about what this is and what we are proposing. The APR 13 requires members whose address of record is not a physical street address in Washington to designate a resident agent for the purpose of receiving service of process. So yeah, thank you. This requirement seems pretty unique to Washington. So we were curious about other jurisdictions to find out what they do, if they have anything similar. So we surveyed all jurisdictions and we heard back from 25 of them, including Oregon and Idaho. And none of the jurisdictions that responded to our survey have anything even remotely close to a resident agent requirement. So we thought that was an important piece of information to share with the Board of Governors. So next slide. So because it's so unique to Washington, you may be wondering, why do we even have such a requirement? Or at least I was wondering when this all came up. And it essentially goes back to when Washington residency was a requirement to practice law in the state of Washington, right? So that requirement, as far as we could tell, could be traced back to the State Bar Act and actually even to session laws, I think 1917 we found. Based on our research, it looks like the Board of Governors at the time in 1981, I believe, it started to explore permitting non-resident lawyers to practice in the state. So I think in 1982, the court adopted a rule eliminating essentially the residency requirement to practice in the state. At the same time, imposed a requirement that those who do not live in Washington or do not maintain an office in the state, that they be required to provide a resident agent for the purpose of receiving service of process in the state of Washington. In addition, in 1997, the bylaws were amended to allow out-of-state members to vote within the district of their resident agent or the district in which they conduct, their primary practice, if they do practice in Washington. The last big change, in terms of this requirement happened in 2017. So at that time, the requirement moved from APR 5, which is an admissions requirement, to APR 13, which essentially means all members must comply with the requirement, not just those coming in. The requirement was also expanded to include those with a PO box in Washington. So remember, before it was about Washington residency, right? Not being a resident of the state. And then it now was expanded in 2017 to include PO box. So what that meant is a lot of people became subject to the new requirement, right? Starting in 2017. And that's when we started to get feedback from members. So next slide, please. So today, I would say about 13,000 members are required to comply with this requirement. And then the next slide, please. We can see that we've been engaging in a gradual approach for enforcement, right? And it usually starts with sending a reminder email and explaining what the requirement is and asking members to comply. So the last time we did this was late last year, and we sent an email to about 4,000 members who were at the time non compliant with the requirement, asking them to do so and provide us with a resident agent. What happened is we heard from hundreds of members reaching out and providing feedback about this requirement. And as you can see here, I broke down the feedback. Usually, can be categorized into four items, four types of concerns. One, we heard from members who believe that the rule is pretty ambiguous and there are multiple ways to interpret the requirement. We also heard from members some serious and invalid concerns about privacy and safety. And by that, I mean, I think there is an impression or understanding that they would have to provide their home address, which is not the case. We don't require members to provide their home address as their public address. But they felt that if they were working from home, that would be the address that they would have to provide. And there was obviously a very, big concern about doing that. We also heard from inactive members who are obviously not practicing law, and they just inquired, why am I being asked to provide an address for the purpose of being served? I'm not even an active member. And then there were folks who really believed that a PO box should be sufficient to meet the requirement. So we heard from lots of members. I spoke on the phone with lots of members. So we decided, so again, this was late last year, we decided to put enforcement on hold. So we communicated that to the court. Obviously, it's a court rule. So we felt like we needed to communicate with the court that we were putting that enforcement on hold, and inform the court that we would be looking at the requirement and making a recommendation. So essentially what you see here is our recommendation after hearing from many, many members and doing some research to understand the purpose of the rule, what it's trying to accomplish, right? And what it means to have this requirement now in 2024. So essentially what we determined is that the requirement is antiquated. As you can imagine, is burdensome, right, on members who would have to find someone to agree to receive service on their behalf. And for the most part, it doesn't seem to be needed. So the agent of service is not something available in the directory. So we are usually asked for that information and we provide. And talking to people who have been here for decades, anecdotal information that very rarely happens. So it's not even something that it's being used, right? Or seen as helpful. So here you can see all of, we broke down by rule, so we can just provide a summary, but obviously your materials have a lot more information. So APR 5, the amendment there would essentially be to remove the requirement. APR 13, the amendment there would be to remove the requirement from members, and APR 5 remove the requirement for applicants. APR 17AF removes failing to designate a resident agent as grounds for suspension. And then 17B, that is a little bit different from the resident agent requirement, but we are also recommending a new subsection that would make the act of recommending suspension for failure to notify the bar within 10 days of a change in contact information. Right now, we have an obligation. It's a mandatory act of recommending suspension. We would like for that to be a discretionary act. And I say that because it's really hard to even know if someone is not complying with that requirement, right? So unless we get returned mail, it's nearly impossible to know if someone moved and haven't given new address to the bar within 10 days. So we believe it's a very strict requirement. So we prefer to first reach out to the member, and ask if they could update their address. And then if needed, have that ability to recommend suspension for failure to comply with the requirement. And then finally, ELC 4.1 removes the resident agent as an option for personal service in disciplinary proceedings. This is something obviously we consulted the Office of Disciplinary Counsel on. They indicated it's very infrequently used and agreed that the benefits of eliminating the resident agent requirement outweigh the minor burden of having to find an alternative means for serving someone in the disciplinary proceeding. So this is a summary. I kind of want to go back to the rule. Sorry, Bobby. I just want to see, before we move to bylaw changes, since this is something we were hoping for action today, and the bylaw changes are for first read only, I was curious if there are any questions on the actual rule changes that you want to address now, or if you want me to continue and go on to bylaws.
Should have been asked by me months ago or in the future, but to me, I guess I'm having trouble trying to think of figure out why any of these rule changes are needed if the only real purpose today is to allow a victim of an attorney's malpractice to be able to find the attorney and sue him. To me, just off the top of my head, my initial thought would be, look, if I'm a corporation and I'm going to do business in Washington, I have to designate a registered agent, period. That's it. Or if I'm an insurance company and I'm selling somebody insurance, I, by law, designate the insurance commissioner as my agent for service. And so it could be something as simple as, if you're an attorney licensed in Washington, you designate the Bar Association or something as your agent for service. And they have to keep up to date in the bar registry. What's the contact information? Or just designate a registered agent. But anyway, those are my thoughts, but I don't want to side rail everything because I know y'all have worked all this, but I don't understand the purpose for a more complicated solution. That also gets us out of the job of having to enforce anything. But anyway,
Chief Garcia, do you want to respond to that?
Thank you for your comment. Well, I'm not sure if, are you thinking it might be easier or better for the Bar Association to take on that responsibility of accepting service?
Yeah.
I want to clarify because I'm not sure I totally understood the comment, and then Hanata's response made me think maybe she didn't either. What we're proposing here is completely eliminating the resident agent requirement.
oh, no, I'm fully on board with just getting rid of all that stuff. My question is, if it seems to me, though, that a valid, legitimate purpose of having something like that is, if I'm a client who's been that's been harmed by an attorney, I want to be able to find that person as easily as if a corporation harms me.
Gotcha.
Or if an insurance company harms me. And so just designate a registered agent. That's just part of the cost of doing business. But anyway, I'm not saying this is a bad idea to get rid of that stuff. I'm just wondering if there's another purpose we should be thinking about at some point.
So Chief Garcia, any comment on, are we taking away sort of a useful tool for somebody to contact an attorney that they have a complaint about?
In theory, right? But like I said, in practice, it's not even known to the public. If you think about it, it's not on the directory. It's something someone would have to be aware it exists and ask us for it. And part of the reason why it's not published is because some members choose to put their home address as an agent of service, and we are not recommending at this time that address be made public, right? So we don't even believe it is public knowledge. But to your point, that's true. And there are other ways to locate members, right, who are registered, have a business. Or there are other means to serve someone that does not involve physical address.
Okay, I think we have Governor in order. Governor Fay, Governor Whitney, Governor Wen. That's the order so far.
Thank you, Madam President. This doesn't mean, I'm sorry, when I renew my bar card, the bar knows my physical home address. We just don't publish it, correct?
Correct.
So an enterprising, I don't know, disciplinary council would have no problem in hunting these people down. I mean, the registered agent, you're saying it's never been used to sue these people, which is pretty good indication that it's not necessary. So how do people go about it now without a registered agent? How do you find these people, Doug?
I just, sorry, really briefly, I just want to say I believe it has been used, so I wouldn't say it has never been used. We just don't think it has been used enough, like maybe once a year, if that, right? With all the members we have, they're supposed to have this requirement.
So, thank you for the question, which I think was, how do you find these people? The rules for enforcement of lawyer conduct require personal service of certain types of disciplinary process, if you will. And there are multiple means of serving respondents who can be found in the state of Washington or who cannot be found in the state of Washington. One of those many means is service on the registered agent. We sometimes do have difficulty finding respondents, and some respondents do evade a disciplinary process. We have substantial staff and technology resources that we deploy when we need to find a respondent who is difficult to locate, including professional investigators on staff. By and large, we find them. From time to time, we resort to service on the resident agent. It is the means of last resort when there are no other options, but is fairly infrequent. And there are other means of substituted service that are also valid. So that's the reason why the law of the resident agent option, which is nice to have, but not critical, was not concerning to the Office of Disciplinary Counsel, although if there was an alternate means of service on an entity designated as a resident agent, we would certainly have no objection.
Governor Whitney.
Thank you. I am wholeheartedly for this. Personally, because as someone who works for a larger business and all of our offices have been turned virtual, personally, I had a very aggressive attorney that was using this registered agent as a way to try and get my home address, which I don't think we should have to, as people of the bar, give our home addresses for a registered agent for someone to be able to call and have our home address. So I don't think it's necessary. I understand more for the oh my gosh, for trying to find people if there's some sort of action by the bar that needs to be taken. But as practitioners, I don't think it's necessary. There's so many other ways of service. And so I thank you, Hanata, for all of your work on this. And that's all I have to say.
Governor Wen and then Governor Petrosik.
Pardon my ignorance, but if you have a company or a solo practitioner in the state, don't you have to register with the Secretary of State for service? No? Oh,
Are you sure?
yeah.
I thought all corporations had to have a
Corporation, yeah.
Yeah, a solo practitioner may.
But
Oh,
if you're
it-
a solo practitioner, you're just a dude.
If you're doing business in the state, don't you have to register?
You're just a person.
Okay, Mike.
Oh, well, that was just my question. But my other question is, do other profession do this? Like, do the doctors for the purpose, or accountants?
Chief Garcia, was that something we researched, whether other professions do this?
No, I just limited to lawyers and looked at other states.
Governor Petrosic.
Just to reiterate basically what Governor Whitney said, I've heard from many people in my district and who I also serve as a liaison to concerns about the registered agent requirement. I'm a solo attorney myself, and since 2015, when I went solo, my office has been in my house. I definitely don't want the majority of the clients who I represent knowing where I live for fear of what they might do to me and or my house or my family. So I fully support the elimination of this, and I know many other people who I've spoken with have been very concerned about this provision being in our rules and would also wholeheartedly support the removal of this.
Anyone else have questions or comments or thoughts? Seeing no hands raised, I think we can put this matter to a vote. But we need a motion first.
I motion.
Second.
Discussion. Now we can put the matter to a vote. Oh, I'm sorry, Tom. Governor Ahern.
On the
Sorry about that.
discussion part, I mean, I will be voting in favor on the theory of protecting attorneys. But I hope that our next step is going to be doing something to protect the public on making sure that a member of the public who's wronged by an attorney can easily track down that attorney to serve that attorney rather than, because frankly, if there's anybody who's smart enough to evade service legally, it's going to be an attorney. And it's going to be an attorney that's committing all kinds of malpractice. So I urge us, once this is all over, to now look at what are we going to do to protect the public in this regard.
Thank you, Governor Ahern. Anyone else? Governor Williams-Ruth.
And this is just a question, as I've been listening to the debate, even if a solo practitioner is just their own solo, does anyone know if they still have the obligation to have a master business license through the Department of Revenue? Because again, I'm a PLLC, so I had to register with Secretary of State and then also get my master business license. And I'm just trying to think of ways, again, feeling the same way as Governor Ahern is, what are we doing for the public? And so I'm just trying to think if somebody is truly a solo shingle and they're not incorporated or in any form of legal entity, is there an obligation or any avenue by which they can be found? Because again, I will be very honest. When the wildfire broke of the public, I said, you know what? A $40 annual and registered agent fee is not unreasonable to protect the public. And again, I do not want people's home addresses out. I don't want them out for attorneys, for judges. There's a real safety and issue concern, but I feel as though this could be ultimately creating a lovely safe haven for, again, those that need to show up and be found. So, thank you.
This is first read.
There was a question as to whether this was a first read. So the bylaws only require a first read on bylaw changes. So part of this is a set of bylaw proposals. So those are on for first read. You could choose to have this come back, or you could choose to take action on it today.
Governor Williams.
Wouldn't it be prudent, since we're doing this as a hand in hand with their a rule change and a bylaw change, that we do them concurrently? Because if for whatever reason the bylaw change doesn't even go forward, or what if because our bylaws, correct me if I'm wrong, our bylaws still have to be approved by the Supreme Court. And, I would want to couch anything on, that we move this together as a unified package, and it becomes effective upon, presuming passage and then adoption by the court.
Chief Garcia, any reason that we shouldn't wait and do them together? Was there any urgency?
I guess we could wait. It's just we would like to have this in place before licensing opens up, right? And the idea would be to send it to the court, and then the bylaw amendments would be sent right after, assuming the court approves the APR 13.5 changes, right?
And just what might be obvious is these are court rule changes. So even if we approve them today, they have to go through the court's rules process. So that's the timing
Right.
consideration.
Yeah.
Governor Rathbone.
Thank you. To answer Governor Wynn's question, I pulled it up on the Department of Health for the physician search to see what doctors provide, and it's through the Department of Health, which I would understand that with a physician search, that would be the one considered to protect patients, and it's their credential number, their credential type, the issuance date, the last issuance date, expiration date, active, and whether there's been enforcement action. There's no information as to where this physician resides or any address like that. And this is a real example. He's my former family care doctor, and I can vouch for these results.
Good job.
Any other questions or comments?
I see there's a comment in the chat, which we're trying to avoid that. So I'm going to ask Nancy, would you like to make a comment, or would you prefer I read your chat? There we go. I did. You want to recognize her?
Yes. Recognizing public member Nancy Hawkins. Welcome, Nancy, to the
Hi
discussion.
there. My concern is that lawyers, this whole thing started when lawyers received notices of possible suspension. So if it's going to be postponed, they should all get letters saying that action is void while the board works on this topic, so that people aren't worried about it. And then if we do go forward and pass it, and I heard from Doug the issue of, like, how do they find attorneys that are difficult to locate? And I heard, I think it was from Tom, about how do clients reach lawyers who need to be sued. And I guess I would say pass it now and then see over the next 12 months if this really is a problem. How are we getting complaints from the public that they can't reach somebody they want to sue? Because otherwise we could ultimately pass something that corrects Doug's concern that it requires personal service to take disciplinary action. So maybe that could be noticed to the last known address provided by the attorney with their most recent renewal. So there are some other options that could be considered, but an awful lot of people are concerned about this resident agent issue, and it goes a long way to keep members thinking BOG is understanding their concern. Thank you.
Thank you, Nancy. Procedurally, I'm sorry, go ahead, Governor Dresden.
Thank you, Acting President Angelo. Just one quick comment, which is I think Tom and Brent had made good points. I'm going to vote for this, but I just wanted to say that I think even under the current system, if I understand the statistics that Hanada put up there, like there's like thousands of people that aren't in compliance, and we're not pursuing enforcement against. So I guess my point is that if somebody, even under the current system, wants to avoid providing their address and to, not be found, like the current system isn't, requiring that. So the same issue that you're pointing out still exists now. So I think that we should pass this now and then worry about that perhaps later.
Chief Garcia.
Yeah, as it relates to a question, an earlier question, it was brought to my attention that the WISPA website actually has a page called Starting Your Own Law Practice, and it states, accepting fees for your services means that you must acquire a business license from the state of Washington and from the municipality where your practice is located or conducts business. So I think that might help answer some of the questions from earlier today.
Thank you, Chief Garcia. Any other questions or comments? So I believe we did have a motion on the table with a second. And if there are no further questions or comments, we're going to proceed to a vote.
And so just to clarify, this is a motion to approve the proposed changes to the APRs and the ELCs, not the bylaws. Those are on for first read.
But this is a first read of the bylaw.
Correct. Francis Adewale.
Aye, reluctant aye.
Reluctant aye, noted. Tom Ahern. Reluctant aye.
Aye.
Todd Bloom.
Aye.
Jordan Couch.
Aye.
Matthew Dresden.
Aye.
Kevin Fay.
Aye.
Christina Larry. Nam Nguyen. Kari Petrasic.
Aye.
Mary Rathbone.
Aye.
Allison Whitney.
Aye.
Brent Williams Ruth.
Aye.
Motion passes unanimously.
Thank you, everyone, for that discussion and the vote. And next, I will allow Chief Garcia to continue on to her next item.
Thank you. All right, so for part two, the first two changes you see here are essentially corresponding changes, right? What you just approved for the APR, which is also found in the bylaw. So the third one is where I think we need to spend a little bit more time. And at that is essentially an unintended consequence of eliminating the requirement, and that relates to elections. So currently, members who reside out of state can vote in the district of their designated resident agent or the district of their primary practice, if they practice in Washington, of course. So currently, members residing out of state can currently participate in two elections, right? Congressional and at large. Our proposal, and again, this is for first read, would be to continue to allow out-of-state members to vote for at-large positions, of course, and continue to be able to vote in the district of their primary Washington practice, right? However, because we are getting rid of the resident agent requirement, we are now recommending that members who reside out of state are not able to vote in the district of their resident agent. So essentially, those who live out of state and do not practice in Washington would essentially only be allowed to vote for at-large positions. So that's essentially, the resolution we came up with. Of course, this is for first read, so if you have any feedback, we can come back with a different proposal and, make any changes you think are appropriate here. That's all I have for the bylaws.
Thank you. And next, Governor Ruth Williams. I'm sorry, I haven't had enough coffee. Brent, I apologize. I really do know your last.
Quite all right. I've been called many things. I am not in favor of this because the fact that just because we're removing the requirement to have a registered agent doesn't mean people still won't. And if they elect to have one and have a presence in Washington, then they should have their congressional representative. And also, because again, will that then make them ineligible to run for that seat if they're no longer considered part of that district? So I am not liking this on a first read and would ultimately vote no on a second read, because I think, if people continue to go, then they should continue to have the same rights that they've had since this was initially, codified. Thank you.
Thank you. Governor Fay, then Governor Adewale, then Governor Couch.
There are statistics in the materials that are at the end, and I haven't looked them up, but we have thousands of members who do not live in the state of Washington. Who do they vote for today? Because the congressional districts, you have to live in that congressional district. That it's the home address.
Or the registered.
Right. But today we've got thousands of members out there who don't have registered agents. Where do they vote? What congressional district? Or do they just make something up from a former address? But most of these people don't have registered agent. How do they vote today?
Chief Garcia, do you want to answer that question if you can?
That's in Paris.
Or-
Question.
Yeah.
I was actually looking to see if Paris is here to talk about election.
Paris question.
Harris, if you're available and have the answer, I've unmuted you.
Oh, yes, I am here. Thank you. If we don't have a resident agent for them, then we can't correspond that to a congressional district. So they wouldn't vote in a district position. So if we don't have that information, we wouldn't be able to ascribe a district to that individual.
Okay, so that's basically what we're doing today.
For people who are not compliant with the requirement, yeah.
Would they vote for at-large, Paris, under the current framework?
Yes.
And under the proposal, Chief Garcia, would they still vote in the at-large?
Yes, and if they practice in Washington, they could request a ballot, right, in the district that they are practicing.
Mhm. But my point, I guess, is that we're really not changing our practice.
For the members who are not compliant,
Right.
that would be essentially the same, yes.
Madam President, if I may, we are going to change our practice for the people who are compliant. And even though they won't be in compliance because it won't be a rule, you're still taking away somebody's vote who has one. So again, I don't care about the people who have been violating the rules openly and not compliant with the rules, and the fact that the association hasn't been coming down like a thundering horde that they were saying on the listservs. The fact of the matter is there are people who live out of state who have registered agents. Why are we going to strip them of one of their votes? That really doesn't seem like a very good way of being, stewards of our members.
Governor Adewale and then Governor Couch.
I'm worried about this. I agree with Governor Williams' rule. When I was in my first run for District 5, I requested for the list of voters in my district. And I was shocked to find 2 pages of people with some in the military, some in California, all over the country. I corresponded with them and I got a response back from them. I'm concerned about, taking away their vote with this decision. It's still a first read? Okay, I think we need to think this through before we make a decision on this. Especially the people that will be impacted by this decision, they should have a voice. And I think that every one of us that are district governors would have people on our list. If you request for a list of voters in your district, you will find people like this that will be impacted by this decision. I think I hope that we have consulted with them, we communicate with them about what we are doing, and I'm going to vote nay with Governor Williams-Root on this because I'm really concerned about it. But I'm glad that this is just first read. We are not voting now. I hope that Chief Garcia will go back and reflect upon some of the comments we make today. Thank you.
Governor Couch.
Yeah, thank you. So Chief Garcia, I just kind of wanted to ask, because we're talking about this, but you actually have the information on this. What was the reasoning behind making this change as well? Because I do see the point of, if you're cleaning it up, you kind of go through and clean these things up. But I do understand Governor Williams-Ruth's point that, like, I don't know if this is a needed change with the other amendments. And is there something in your conversations that said, like, with these amendments, we also need to ensure that those with a registered agent who keep that also change their votes? Or was this just kind of a part of cleanup?
So because there was no requirement, we were eliminating also, right, any connection to that requirement in the bylaws. What I'm hearing is that maybe you want to explore an optional, right? It's not a requirement, but people could provide a resident agent, and then they could either vote based on that address, or if they practice in Washington based on that address. So we can definitely look into that. I imagine that this would, lead to a lot of thoughts on this issue. The other extreme, right? So obviously we don't want to disenfranchise our members out of state. Another thing that crossed our minds, and again, that's why this is first read, you could potentially create a new seat and have an out-of-state position, right? And then allow people with an out-of-state address to vote for that position. So there are many ways to look at this. So thank you for the feedback. And yeah, I think we'll come back once we have a little bit more direction from you today.
So I just want to say that actually is something the WILC made a decision to do a few years ago, to take they had 3 just at-large seats, and they wanted one of them to be committed to being a representative of the members who are not residents in the state, because we had geographic diversity and we felt like that was a good continuation of that. So that's an interesting idea. And I just want to say worth conversing, and we have a great example with the WILC already.
I'm going to take Chief Disciplinary Counsel Doug Ende, then Governor Fay, then Governor Bloom.
So I did not anticipate the dialogue taking this turn, and maybe just because I didn't have the foresight. My understanding, and I think Chief Garcia agrees with this, was that the vision was the registered agent requirement would go away, and then there would be no more such thing as a registered agent. Now, if there's serious consideration being given to retaining something called a permissive registered agent, the Office of Disciplinary Counsel would like to be able to continue to serve respondents through their permissive registered agents. Now, you've already voted on the ELC change, so perhaps that's a done deal. And maybe this ultimately will not be where this lands. Maybe they won't be registered agents. Maybe there'll be some other type of thing, or maybe a different solution entirely will be settled on. But if there continue to be registered agents, I would like the board to think about taking away the option to serve resident agents.
Thank you, Chief Ende. Next, Governor Fay.
Thank you, Acting President Angeville. If I live in New York City, can I vote for a congressperson in the 9th district in Washington? No,
If your residency is here.
but
Just 'cause you
we're
live in
talking
New York
about,
doesn't mean you're a New York resident. Exactly. I have a lot of clients that are out, sorry. I have a lot of clients that live out of state that have maintained their Washington residency for any number of reasons. So just because you live somewhere does not mean you're a resident there.
Governor Williams, Ruth, and governors, I appreciate your comments, but we got to have a queue. We got to respect the queue. Governor Fay, were you done?
I would aver that, yeah, people maintain their residency, but they have to have some minimum contacts to the state. Now, the resident agent shouldn't be that, because I want to vote in 7 North, so I'll pick a resident agent with an office in 7 North. But identifying which congressional district a person votes in based on who they hire as resident agent doesn't make any sense to me, because there is no geographic representation of that person.
Governor Bloom.
Thank you, Acting President Angel. I was kind of thinking along the same lines as Governor Fay, that and kind of to Governor Williams Ruth and response, the clearly, there's a difference between domicile and residence. And you could be a resident of multiple states and have a domicile where you're registered to vote and where your permanent address is, where your tax home, if you will, to borrow a reference from the Internal Revenue Code and tax law. But I mean, that's I was going to echo the point that Governor Fay made about, if I mean, I'm a member of multiple bars. I don't know how many of us here are, and it's that kind of thing where, if you're living and practicing in another state and you retain your Washington law license, how much interest do you have in what's going on, and how much is going to sway that election? I mean, when I was elected, I think there was something less than 10% of the eligible attorneys in the district voted, 9.5% or so, maybe, I think. And so are we sweating this for, a cohort, a group that's even if it's several thousand are inconsequential, or as with regards to the impact on the bar and their opinions? So many of the membership at large, have a complete and utter disinterest whatsoever in the bar governance. So, I mean, although clearly, I don't want to just go around disenfranchising people if they've lost interest and they're not motivated to vote. Can they engineer, their representation by hiring a registered agent in District 10 or District 5 or whichever, what have you? It just almost, there are competing interests. I understand, but it's, the impact on it seems rather vanishingly small, frankly. And, I'm kind of surprised we've taken as much time to really go through it. Would I tend to vote against, because I don't think, we necessarily should have to have registered agent. The point is, I guess, if there's a means of tracking you down to hold you accountable for malpractice or whatever kind of damage you may have caused or occasioned someone, I'm in favor of that. But it just, I'm not quite sure this is the, solution in search of a problem, almost kind of. So clearly, internal consistency of the court rules, the disciplinary rules, and the bar rules, I think, has some level of importance. It's I'm not quite sure that this solution really addresses it. So, all right, yield back. Thank you.
Governor Nevitt, and then Governor Ahern. I'm sorry.
Different time. I got
Executive
you.
Professor Nevitt.
Sorry.
Again,
Governor
good
sounds
thought.
nice. Okay. One thing, this may be obvious, but I just wanted to also remind everyone, as we're talking about contacts and all this, that part of the proposal is that folks who do practice in the state. So for example, we thought about people who might live on the border in Idaho or in Oregon. If they practice, they would still be able to request a ballot. So we did that's part of the proposal. I also just wanted to see if it might be possible, and it may not, to get some clarity or consensus about what we should bring back. I think absent that, we may just bring back options for you to consider, but if there was an opportunity to see if there was consensus, that would be helpful.
Thank you, Executive Director Nevitt. And next, Governor Aaron.
Since this is the first read and something's going to be coming back, I just want to say that I support the idea of at least exploring, and I'd probably vote for it, having a separate at-large seat for the out-of-staters. Because I do think they have a specific type of interest. And what we're doing is if we're just spreading it around so it's watered down a little here, a little there, somewhere else, their interest isn't being represented. And it sounds like there are enough out-of-staters that they're not like an inconsequential handful. But I just request that that be thought of.
Next, Governor Williams-Ruth, and then Governor Adewale.
So 2 years ago, we went to Idaho and we got to hear that they have what they call their zero district, which is the representative on their board for all residents or for all non-Idaho residents of the Idaho Bar, which, if I remember correctly, was actually their largest district. And again, I'm in favor of it. Prior boards were not, which is why I haven't been advancing it. I think it's a good idea, but we also need to understand that the cost with that. And, you know, if we have someone who's serving in the military that's in Ramstein Air Force Base, are we going to pay, or are we going to say, oh, no, we only pay for their travel within Washington State? Because, you know, again, I'm not one to say money is a reason not to do something, but I just want to make sure that if we do it, that they are going to be a full member of this organization, and we're not going to throw up barriers and say, oh, well, you're a member of the organization, you pay full dues, you've been elected by your members of your district, but we're only going to pay for your travel once you cross over Washington state lines. And so, you know, and that there's probably a rule about that and how it happens and whatever, but you know what the cost would be if we have 10, you know, round trip flights to Europe to come back. So again, I think it's a great idea. I would get behind anyone who wants to do it. I just want to be very transparent about what that would look like to actually create a fair representation. Because we have, for those who don't remember, we actually had a colonel in the United States Army who worked for the Air Force Academy seek to be appointed. And, you know, and she wasn't successful. She then did go on to serve on the Washington State Bar Foundation board, but there are people who do care and would do it, but how are we going to treat them when it comes to their expense report? Thank you.
Governor Adewale.
As the treasurer of Washington State Bar Association, I care about the fiscal, I care about the fiscal impact, but I don't think that should play a role in asking someone that is serving this nation in the military to come and be part of the Bar Association. I just don't think that is, well, coming back to this issue, I agree with Governor Tom Ayan. I'm very concerned. I would recommend to Chief Garcia that when this come back to us, they come back with options. I'm very, very open to the idea of creating a seat, but I'm more concerned. Even that would not still address my concern, because I was looking at past President Kyle Shusheti here, because, you know, he practiced in Spokane, and he used to practice in Spokane, and he's currently practicing in Vancouver, and he's licensed in Oregon. We have a lot of people in those border cities. In Spokane, there are attorneys that practice in Spokane, but are resident in Coeur d'Alene or Post Falls, Idaho. That's their primary place of residence. You will disenfranchise them. They know the bar in Spokane more than they know the bar in Idaho. Why should we discriminate against them? Why should we not? Why should they not be able to vote in 5th district? The same deal with Vancouver and Portland. We still have a lot of members that live in Portland but practice in Vancouver, vice versa. I'm concerned about those ones. Those ones should have representation in the area closest to them without having to go through all of these issues. So those are the concerns, and I hope, Chief Garcia, when this comes back, that all the options are available that we can look at and make informed decision. And hopefully we would, I don't know how we're going to do this. I would really love to have people that will be impacted by the decisions to be able to have a voice in this process. If there is a way to be able to send a correspondence to them and say, look, these are proposals before the Board of Governors. If you have any comment, please let us know about them. I would really appreciate that. Thank you.
And next, Governor Dresden, and then past President Kyle Schicchetti. I'm not sure which person was first, so forgive me.
I think Kyle was first, but I'm happy to go first. So just one comment. I mean, I think these are really interesting discussion about enfranchisement or disenfranchisement. I'm a member of California and Texas, and I will just note for context that at the previous Washington State Bar Conference that I attended in Hawaii, which is 3 years ago, I was recruited by the State Bar of Texas because they could not find people to serve as their out-of-state representative. And that seems to be an ongoing issue with them. I don't know what the experience is in Oregon. I think it may be different, right? I think Texas doesn't have a lot of large border cities where there are people doing so. So I don't know. But I'm just putting that out there. That was a problem. So much so that they're like, hey, wow, you're licensed in Texas. Would you like to join the board? So that may be something to consider as well, that it may be difficult to find people.
Past President Schicchetti, welcome to the conversation.
Thank you. This is a very interesting conversation. I missed part of it. I was on calls, but this last part is very interesting to me. I've shared this story a few times with a few individual people, but not all of you. I was your president only because the folks in Oregon voted me in as District 3 governor for Southwest Washington. They were the ones that had registered in the Vancouver, Southwest Washington, Clark County. So they got to vote. And I won that election very narrowly, but it came from Oregon attorneys. I am now having the pleasure of serving as the out-of-state representative on the Oregon State Bar Board of Governors. And every year there's 3 or 4 elections for different regions in Oregon. I was the only contested election. All the other ones were uncontested, and they were sat immediately as were declared the winners, I guess, immediately and subject to being sworn in. And it was a race, and we sent out. My opponent sent out postcards. We sent out emails. In Oregon, the out-of-state members of the Oregon State Bar is the second largest group of attorneys, Portland being the first. But it dwarfs Southern Oregon, Eastern Oregon, any of the other regions. The outer state members are by far outnumbered. They outnumber the other regions. And they haven't had the out-of-state representative very long. I think there's only been 2 or 3, 2 prior to me. They've both been Vancouver residents because that's the biggest area of people who would be voting in that election. If you did something like the out of state, you would then be, I think, preventing Oregon attorneys living and working in Oregon from voting for the people who would be in Clark County and probably Spokane for Idaho. And you would be creating a larger pool of folks that would be represented. And, they've done it successfully in Oregon. They haven't said anything about limiting reimbursements. Now, of course, I'm coming from Vancouver, and that's not a long ways away. But there's no rules that say if you came from California or Texas, they would probably reimburse those expenses. But again, you're most likely going to pull from the bordering states. But it's a good program, and I've enjoyed doing it, and I've enjoyed reaching out to all of the out-of-state members for the Oregon State Bar, and I encourage you to think about that because I think it's an excellent idea. It's proven to be successful in both Oregon and Idaho, and I imagine many other states.
Thank you, Past President Cicchetti. Governor Williams-Ruth.
So just to give context, as someone who has been in love with the demographics report since I joined this board, I will just say that the non-Washington contingent is the second largest district, only behind 7 South. It has 5,097 members. There are approximately 40 members who are in the armed forces in Europe, Middle East, or Pacific. We have 2,000 California attorneys, 2,700 Oregon, and then there are 465 in Texas. There are, I didn't count, I didn't have the time, but it looks like every single state is represented, including then multiple Canadian provinces, Quebec, Nova Scotia, British Columbia. So again, and this is since I switched over from a congressional seat to the at-large seat, I have been doing my best to make sure that those voices have been represented because it is. I mean, I technically represent all 41,980 members, but it's the 5,097 that don't have anyone else here at the table except for Governor Ahern and I. Technically, Governor Couch is just working for those young ones of the 5,097 or new and youthful members or whatever we call them now. So I think it would be a great idea. And again, it was something I thought was a great idea when I first learned about it on our visit to Idaho. And if there's support for it, I think we should look at making it happen.
Thank you, Governor Williams-Ruth. And next, Chief Communications Officer Sarah Nagowski.
This is a PSA because we've gotten feedback on this. We have updated demographics on our website every month. All you have to do is Google WSBA demographics. You'll come to who we are, scroll down, and it says demographic sheets. We get that a lot. We heard on the listening tour, people would like to know what that is. We have a standing item and take note that will point you to the demographics. So go check it out. Brent's looking at them. Jordan's looking at it. Just Google it.
Thank you, Chief Nagowski. Anyone else have any questions or comments? Yeah, probably. So at this point, there has been a motion. No motion. Oh, because it's first read. I'm sorry. So if that has exhausted the discussion on first read, I will call on Chief Renata Garcia to go on with her amendments.
Thank you. This was good feedback. We'll come back with some options next time. Would you like me to go on to the next topic or?
Yes, please.
Okay, thank you. So now we are transitioning to admission fees. Nothing to do with license fees, admission fees. This is a recommendation from the Budget and Audit Committee to increase admission fees starting on page 211 of your materials. So The admissions cost center captures all the costs associated with administering the bar exam, reviewing applications, and all of the functions related to getting people admitted to the practice of law. The fees are set by the Board of Governors, subject to review by the Supreme Court. And the fees are not intended to generate revenue, right, to the bar. They're intended to cover the costs of running the admissions cost center and be revenue neutral and just break even. We have been able to accomplish that for years. Fees have been the same since 2009. Not 2019, 2009. So for almost 15 years, we have had the same admission fees. Unfortunately, this is no longer possible. So if you take a look at page 215 of your materials, you see that last year we operated at a deficit, and we are also budgeting at a loss this year, projected to budget at a loss. And we'll continue to budget a loss unless fees are changed. So if you take a look at page 211, you see that we are proposing very modest increase for applicants who are not admitted to the practice of law in any state or jurisdiction. And those who have been admitted, but have been admitted for less than 3 years. Essentially everyone who does not qualify for admission by motion currently. And then we are proposing a much more substantial increase for those who have been admitted to the practice of law for at least 3 years. That was a very, deliberate decision because we are making an assumption that the costs associated with seeking licensure in Washington are more likely to be a barrier, right, for law students and recent grads and people who have not had the opportunity to practice law than to those who have had the opportunity to practice law for at least 3 years, right? This is also common practice across the country. States usually charge more for admission by motion, pro hoc vitae, those types of applications from members, from people who are licensed in other states. We're also proposing to maintain the late fee the same at $300. We are not seeing a significant increase associated with, late applications, so we want to maintain that. We are recommending an increase in the non-refundable amount that someone can get back by $100. And that's because there is a significant cost associated with withdrawals, right? Last minute withdrawals. And some of the costs cannot be recovered. So we want to make sure that we're increasing that by an additional $100. So if you take a look at page 215, you can see 211, you can see the breakdown of the fee that we are proposing. The budget NADA already approved and is recommending that the Board of Governors adopt those fees. It would then be sent to the Supreme Court for final review and approval.
Thank you, Chief Garcia. Are there any questions or comments? Governor Fay.
One of the things when we discussed this at the Budget and Audit Committee, even with this increase, we will be a really cheap state to be admitted to. Most states charge a lot more than has been proposed here, much less what we have been charging. So just as a matter of equity, I think it behooves us to do, increase so that the cost of running the exams is borne by the examinees. Otherwise, the general membership will be subsidizing. And golly, I think the general membership probably would be adverse to that.
Thank you, Governor Fay. Next, Governor Williams-Ruth.
And then just for those who aren't on budget and audit, just full transparency of the fact that this is the fee charged by Washington State. We understand that there are other charges, that this is not just the fee and that's the entire exam, that there are other costs paid to other people. But I will second what Governor Fay said, and it was actually very surprising to me when we asked for and got, thanks to our great staff work, the information about other associations of our size and mandatory bars, that the fee paid to those states in many respects was like double. I mean, there were ones that were, $1,000, $1,200 plus then their NCBE, UBE costs as well. So I think this is again, it was numbers that are still very much in line with our values, and we're not looking to make money, but also not, we're trying to make it as revenue neutral for people who want to join us. And I think it's a necessary step, given that, again, it has been 15 years and the team on the admissions team has been making it work the best they can. So I don't know if there's been has there been a motion yet? Then I move that we adopt the recommended fees for admission fees.
I believe Governor Adewale had a comment to make.
No, not really much of a comment. It's just that the document referenced by Governor Fay and Governor Williams-Root is in page 233 and 234 of your materials. It outlines all the other fees from other states. And thank you, Governor Fay and Governor Williams-Root. I support this motion.
Governor Ahern.
Just to make sure I understand this correctly, this is not, right now we're losing money, and this increase does not make it revenue neutral. It just makes it losing less money. Am I understanding that correctly?
Chief Garcia.
Nope.
Chief Garcia.
Revenue neutral, we are anticipating at least 3 years, maybe 5. So we will have to come back eventually at some point. Yeah.
Thank you.
Anybody else?
Me.
Governor Rathbone.
Kind of piggybacking on what Governor Ahern said, I guess my question would be how I'm in looking at the materials, and I apologize if I missed it. Did we do a comparative analysis to other states?
Yes. Yeah.
Page 233. Okay, I must have missed it. But even looking at that, I guess I appreciate that we want to be modest in our increase. I'm not saying make it higher, but I'm just saying, why are we sort of halfway fixing a problem only to fix the rest later? Again, at the risk of, making people upset about higher application fees. I guess I just don't want to halfway fix the problem. So I guess I would need to hear from someone on the committee why the rate increase is so modest.
Chief Garcia.
Sure. Yeah. I think we were trying, again, we think it's a burden, right? More likely for students and people who just graduated to be paying these fees. So we recognize and wanted our fees reflect that. I also want to point out that, so with Next Gen, things will change a little bit as to what applicants are paying and to who. There are also changes associated with the alternatives to the bar exam that we won't know. We don't have enough information right now to know what that's going to do to the budget. So I think no matter what, we will, unless we are making a really big change right now and creating, right, that buffer, we will likely come back either way, because we will have more information when those alternatives are up and running, right? So right now we currently pay NCBE for the cost of the exam materials, right? And that comes out of the application fee that we collect. So we kind of do a pass through, and that's $132 per examinee. When we transition to Next Gen in 2026, that fee is going to go directly to NCBE. So NCBE is going to be collecting, and it's going to be $145. So just there, you can see that the cost will be higher for the applicant, right? To actually sit for the exam, not what they're just paying the bar. So we took those things into account, knowing like the final cost to applicants when making that recommendation.
Chief Garcia and now Executive Director Nevitt.
She covered it.
Yes.
Oh, all right. Well,
Williams Road.
okay. Okay. Well, we're getting efficient here.
Yeah.
Anybody else have any questions or thoughts? So we have a motion and a second, and I think we're ready to proceed to vote.
Okay, and a reminder, this is a vote to adopt the recommended admission fees. Francis Adewale,
Aye.
Tom Ahern, Todd Bloom,
Aye.
Jordan Couch,
Aye.
Matthew Dresden, Kevin Fay,
Aye.
Christina Larry,
Aye.
Nam Nguyen, Kari Petrasic, Mary Rathbone. Aye. Allison Whitney, Brent Williams Ruth.
Aye.
Did I miss anyone? Motion passes unanimously.
Well done, everyone. I would ask Chief Garcia to continue on regarding the next item.
Thank you. All right, halfway there. So this next item is a APR3 change. So this is a request that the Board of Governors approve suggested amendments to APR3 B3. And it relates to, it's on page 235 of your materials, and it relates to bar exam eligibility for people who have a law degree from a non-ABA approved school. And what we are recommending, so someone can have a degree, a LLM degree from a non-ABA approved law school, either US school, like in the United States, or another country, right? And if they have the LLM for the practice of law, which is a specific requirement set in the APR3, they can qualify to sit for the bar exam. So again, the LLM, the Masters of Law, it cannot just be any Masters of Law. It has to be a LLM for the practice of law, which includes specific instruction on principles of domestic US law, right? So the APR outlines how many minutes per topic. So once they have that, they can qualify to sit for the bar exam in Washington, even if they did not attend an ABA approved school, which is usually the requirement, right? So this rule was adopted in 2014, and pretty much ever since then, we have heard from people who have LLMs, so just I'll call it regular, an LLM, right? But do not have the minimum component of instruction outlined in the rule, right? The principles of domestic US law. So many of those folks seek admission here in Washington. Later on, they were not anticipating, and then they want to transition and get a license here. And that presents a barrier, right? Because they don't have, and the rule requires that the LLM plus, I call it, the LLM with all of those additional requirements, be earned at the same school. So the suggested amendments here, we are hoping to eliminate a barrier. We see this as a barrier, right? So that essentially would allow people with an individual, with any type of LLM degree, whatever that might be, to obtain the additional courses outlined in the rule at another school. That's essentially it, right? Because right now they have to have the LLM for the practice of law, 1 degree, including all of those courses. What we are asking is that we be allowed to accept applications and approve applications from people who have an LLM, and then they do the additional courses due to life, circumstances, things change. They're attending a different school to obtain those courses, those credits. And then we combine the two, and that would make them eligible to apply. So that's the heart of the proposal. Uh, another change we are making, or just making a clarification we are proposing here, is to change the language. So then when we are talking about what degree qualifies, right? We are asking that it be specific to a degree that allows someone to practice law as a lawyer. Because oftentimes we will receive applications from people who have a limited license to practice law, and they're trying to use that rule potentially to obtain admission. But the intent of the rule is really to do almost like a reciprocity, right? So you're practicing as a lawyer, or got a degree that allows you to practice as a lawyer, and then you're transitioning here. So it's a little bit more of a technical change in my mind. The most substantive part is allowing folks to obtain those credits separately. I also want to mention that UW Law School, we have been collaborating with them, and I'm not sure if Carrie Sanford is here or not. But my understanding is that if the Board of Governors approve that change, UW Law School will be co-proponent on this recommendation to the court. Any questions for me?
It's not ABA approved as part of the rule, because as I was reading this in a conversation I had with one of the governors, is the 4A says a graduation with a JD degree from a United States law school not approved by the Board of Governors. So that's not changing. It's truly just the LLM that's not from an approved school, correct?
Correct.
Thank you.
Governor Fay.
I'm going to beg forgiveness here for a little bit. I have some difficulty with this proposal, not because people shouldn't sit for the bar, not because we should not be lowering barriers. I am against it because it does not go nearly far enough. I would bet I have done more work with international lawyers than everyone else in this room combined. I ran Microsoft's corporate subsidiary structure around the world for a number of years. I'm on a first name basis with lawyers in hundreds of jurisdictions. And I recall being in Singapore, getting schooled on the niceties of IRS cost share regulations by a Singaporean attorney who, because was not from a common law country, could not sit for the bar. I think they're particular and they're ludicrous. The purpose of the bar exam is to see if you know the law. That's why you take it. You got an LLM, that's good enough. Sit down. If you practice law 3 years anywhere, 3 years out of 5, it doesn't matter if it's civil or common. I'll tell you, the difference between civil law and common law is way overblown. You know, it's most of the time you don't even notice. I know I committed malpractice by, UK law, German law, and Japanese law. So if we have a lawyer who's been a practicing attorney somewhere else in the world, let them sit for the exam. If they don't know the law well enough, they'll fail it. So I would like to propose rewriting this in a way that is much more expansive for folks to sit for the bar examination. Because the bar examination should not be just a formality. If you can pass the bar, golly, I think you have enough knowledge to practice law in the state of Washington.
So expanding on proposing to also get rid of the LLM requirement, or just
no? If you have an LLM, my proposal is, or what I'm, yeah, you got an LLM from an approved law school, you can sit for the bar. Do away with the 12,000 minutes. Because, good Lord, a person goes to NYU, gets their LLM in American taxation, but can't sit for the Washington bar because they don't know enough about US law. That's ridiculous. It doesn't make any sense to me. Let that person sit and we'll test whether or not they know enough Washington law. That's the purpose of the test.
Governor Couch?
I answered my own question. Thank you.
Okay, Governor Williams-Ruth.
As someone who's spent 3 years talking about licensure, I would like to say that I think we should move forward with the proposal as it is, and then come forward with a different plan that would expand. Because I don't necessarily believe that we are not single product attorneys. Just because you know tax law does not mean that you have satisfied the requirement to be a licensed attorney as the rules currently exist. We don't have specialties. You're not just a tax attorney. You are also a family law attorney. You are a bankruptcy attorney. You are a, UCC and secured paper, commercial paper attorney. So I think that to keep things moving forward with the proposal to remove this one barrier, we should move forward with the proposal, but that we come back with a conversation and a proposal that you can put together that goes through all of the analyses, and we take that up at another meeting.
That.
Governor Ahern.
I agree with everything Governor Brent Williams-Ruth just said. But I have a question then. You mentioned cooperation with UW Law School. Was there any discussion with Seattle U or Gonzaga?
Yes, we did discuss it with Seattle University. They support, my understanding is the program is very new there, so the level of input it's much different than what UW can provide in terms of experience offering the LLM. Gonzaga does not offer that option, as far as I know.
Thank you, Chief Garcia. And we actually have Carrie Sanford from UW Law here, and I'm wondering, Ms. Sanford, if you would like to contribute to the conversation.
Hi, I think Hanada did a great job sort of explaining it, and we're really happy to partner on this issue because we feel like it's an access issue, and I know the WSBA has really obviously been expanding access to the bar. So, and we see that the ability to come back and take courses if necessary. This is something that is happening at New York State. Bar has been doing this and hasn't had any issues that I'm aware of. So we're hoping that this will be considered.
Thank you, Ms. Sanford. And as always, we appreciate any input from UW Law. We are hoping to always remain partners with you on many projects moving forward. Anybody else? Governor Fay?
Back in the day, I thought I heard it. Back in the day when mastodons roamed the earth, I was admitted in New York. And my recollection is that there is no specific course requirement. If you have an LLM from an ABA school, law school, you get to sit for the New York bar. Now, maybe that's been changed, but I know a bunch of people that I got my LLM with who did not have a US practical LLM because, quite frankly, such things do not exist. So New York, you got an LLM, you can sit for the bar. And there's a big cohort of people who get bar admission through that, who I have practiced with.
Thank you. New York's rule has changed, and there is some specificity regarding the course requirements for the New York State Bar in order to qualify with an LLM degree. There are quite a few similarities with Washington State, but Washington is unique in the sense that mandates civil procedure and constitutional law specifically, along with professional responsibility and a legal research and writing course. New York has PR and a legal research and writing course, but then is a little bit, I would say, broader in terms of what subjects can be taken to qualify for the exam. So there are certain courses that are required, just like in Washington, but there's also freedom in the LLM to, if you want to specialize in tax or health law or IP law, there's the ability to do that and also qualify for the bar.
Thank you, Ms. Sanford. Anybody else have questions, comments, any motions to advance?
I move to advance.
So we have a motion that's been seconded. Any discussion? Seeing no hands raised, we will proceed to a roll call vote.
Francis Adewale,
Aye.
Tom Ahern, Todd Bloom, Jordan Couch,
Aye.
Matthew Dresden, Kevin Fay,
But you haven't heard the last from me.
Christina Larry, Nam Nguyen,
Aye.
Kari Petrosic,
Aye.
Mary Rathbone, aye, Allison Whitney, Brent Williams Ruth.
Aye.
Did I miss anyone? Motion passes unanimously.
Great job, folks. And now, Hanada, on to your next item and the last one.
All right. So the next item is also relating to APR 3. This is now APR 3C. And it's essentially a request that the Board of Governors approve the suggested amendments necessary to implement one of the Bar Licensure Task Force recommendation, which is to reduce the number of years requirement of experience required for reciprocity. So the recommendation that the court approved in concept was to reduce from 3 to 1 year, right? The requirements for admission by motion. So to become licensed in Washington after having practiced in another state. Currently, to qualify for admission by motion, lawyers admitted to practice in another state have to demonstrate active legal experience for the last 3 out of the 5 years preceding the filing of the application. So the recommendation before you is to reduce from 3 to 1 year, right? So one thing that the task force that was not included in the recommendation is the number of years that it's when the experience must have occurred, right? So that's the piece that's an addition here. So that's a new piece for you to consider. And we are recommending that it be within the last 3 years preceding the application, right? So right now, 3 years of experience within the last 5 years preceding the application, change from the Bar Licensure Task Force from 3 to 1 year, and we are recommending that the 1 year be within 3 years, right? 3 years preceding the application. And the reason we chose 3, we think it's a good balance between ensuring that the experience is recent, right? And also being inclusive, because we think, there are situations where people might have to interrupt, right? And they might not interrupt their practice, and they may not be able to have 12 months of experience exactly within the past year, right? So that we felt was too strict. So we would hope to expand that to allow people to demonstrate 1 year of experience in the last 3 years. So that's a very straightforward request, but I'm happy to take questions.
You, Chief Garcia. Any questions, comments? Governor Williams Ruth.
So just to clarify again, this is going to be a court rule change, which if goes from us to the court, which is like where the license fees and all that other stuff. So this would kick in after the same time that we have, should the court agree with the new admissions fee schedule, correct?
We really don't know. I mean, I can't really speak to when the court would adopt and make effective. So it's the court could choose to publish for comment. So I just can't speak to that.
In the ordinary course, we know a rule change normally would be published for comment unless the court saw some reason to adopt it right away. Do we know in the ordinary course what they do with admission fees? Do those also get published for comment, or are they more likely to just adopt those? Do we know?
So, okay, so thank you for clarifying. So for the admission fee, we're actually asking that it be effective for people registering for the following, for July. Bobby, I'm trying to think what we think February. So it would
Yeah,
open up
February.
February next year.
It's September 1 would be the effective date.
Thank you. Yeah. So we have a specific ask, right? Because we want to make sure that everybody signing up for an exam is paying the same fee. And we start accepting applications September 1 for the February exam. So that's the day we would ask the court to make effective for the new fees. Does that answer your question, Brent?
Yes, it does. Thank you.
Any other questions? Comments, observations? Governor Ahern.
I can understand the reducing it to 1 year of practice, but I'll just say I'm uncomfortable with saying, well, it could be 3 years ago, because if we want somebody that actually has real experience 3 years ago for a year is a lot different than this past year. Was there thoughts or discussion on moving it to like 1 year within the past year, or I'm just curious as to what the thinking process was on that.
Right. We did think about that. We think it might be too restrictive in the sense that someone would have to actually have held a position exactly for the past 12 months, right, within the last year to qualify. And we know that things happen. Someone might need to take a leave of absence, right, for a medical reason, or might need to take a break to raise a family. So we want to make sure that we are creating, flexibility so someone could establish 12 months, 1 year of experience within a little bit more time. And right now it is 3 years out of the 5. And, I guess we could have done 2.5, but yeah.
I would like to pile on and me too with what council just said. Lots of stuff happens. You can be a first-year associate or start your second year and get pregnant. And if you have a special needs kid, well, you might have to take 2 years off. You might be married to a service member, and it's hard to practice law when you're in Germany, and you come back to the States. I am a person who had to take the bar after practicing law in New York City for 4 years. I was not happy with that. So the ability to come in on motion, I think 1 year out of 3 is just fine, because it's a motion. It's not a slam dunk.
Governor Couch.
So first I want to say, Hanada, thank you for catching the error that I had not included like the actual time period on this. Yeah, that's what it was. So I think I like this was an idea I had, and I will say supported by the Bar Licensure Task Force, but I think the idea of maintaining a 2-year gap makes sense to me, as like that's the maximum gap you can have. That's where we start to say like you need to kind of check in again. That makes a lot of sense to me as for timing, as someone who didn't think of this, but it's it's done better now. Just to give a little background in case anyone's wondering on this, where this came from and why this came out of the Bar Licensure Task Force is that we were looking at the data and looking at the history and recognizing that like really practical experience does a lot more for us than a bar exam does in ensuring competent lawyers. And we're saying based on that, we're making recommendation that really with 6 months of practice after law school, you could practice law in Washington because you've proven your competence. And then at the same time, we're saying, but if you've been practicing law for years in another state, unless that's 3 years, you can't practice in Washington. doesn't really make a lot of sense, that kind of dichotomy. And so this change was part of our recognition that, you know, the data indicates and the history indicates that you can prove your competence to practice in a year of practice. And so that's where this recommendation came from. That's why it's part of the Bar Licensure Task Force. And I would encourage all of you to support this recommendation, because really the data supports this is how we can get, you know, qualified people into the state without creating unnecessary burdens that waste our resources more than anything else. Thanks. Oh, and I'll move to approve it.
Okay. Governor Hayan? Oh, Todd Bloom?
I just kind of perked up a little bit when I heard one of Governor Fay's scenarios. I think aren't military spouses have a carve out or an exception already in the admission rules?
Yes.
Chief Garcia? Yeah, okay. Yes. All right. Any other comments or discussion? In the apps? Online? Okay, member Nancy Hawkins?
Hi there. I want to encourage the board to keep it at 3, if not make it longer. And my concern is that our focus should be on protecting the public and even protecting the court system as a whole. And, you know, I have a case, which I've mentioned to at least a couple people, where someone petitioned for admission from another state, pro hoc vice, and then later by motion, claiming he had 10+ years experience in that other state, and in the past 6 months has been sanctioned multiple times already for violating Washington rules. I think that I would urge people to think back to how, for want of a better phrase, stupid we were in our first year of practice. I think that it takes time to learn how to be a lawyer, to learn how to read court rules and apply them. And it takes a long time to transfer what you know in one state to change how you do things for another state. And I find it somewhat terrifying to think that we're going to admit people based on a year's practice in another state when they probably barely know anything, or most of them. You know, I'm sure some of them know more, but most of them won't. And now they have to shed some of that knowledge and learn different rules in different counties. And I just can't see us accomplishing the protection of the public and the court system with people with 1 year experience. And as I said, even 3, but 3 is better than 1. Thank you.
All right, any other discussion? All right, we proceed to roll call for vote.
All right. Tom Ahern,
Well, I agree with a lot of what Nancy said, but Governor Couch convinced me. Aye.
Todd Bloom, Jordan Couch,
Aye.
Matthew Dresden, Kevin Fay,
Aye.
Christina Larry, Nam Nguyen, Kari Petrasic, Mary Rathbone,
As someone who's not eligible for reciprocity, aye.
Allison Whitney,
Aye.
Brent Williams Ruth.
As someone who's fighting for you to get reciprocity, aye.
Motion passes unanimously.
All right, thank you, everyone. Thank you, everyone. In the spirit of getting,
Sorry,
Chief Garcia.
thank you. Just a quick comment. Well, first, thank you so much for for allowing me to present those 4 topics back to back. I know it was a lot. So I just want to clarify the military spouse, they qualify, but they have to be residing in Washington, right? So, and then the other thing I'll mention for motion applicants, in a way, it can be seen as they already established their competence, right? Because they already took the bar exam in another state and then they practiced and now they're coming here. Whereas with the alternatives is going to be one or the other. For admission by motion, unless they are becoming admitted in a state that waives the bar exam, they already took the bar exam and they're getting experience. So I just wanted to note that. Thank you so much.
Thank you, Chief Garcia.